This is a deep dive video on one of the many topics of the multi-layered subversion of the family court system, which I sketched in broad brushstrokes in my first clip. I will address the subject of attorneys for children, AFCs, and one attorney in particular, Rita Kaufman. This video is protected by First Amendment. After all, New York City Mayor Adams went all the way to Florida to proclaim that in New York City you can say whatever you want, at least as it pertains to the agenda government wants to promote. Rita Kaufman was assigned by referee Alexandra Bayon from the same Richmond County Family Court. She's supposed to represent my children, correct? First of all, why does the state need to insert itself between parents and children? Even if parents disagree, they probably love the children more than any state agent who will pop in and out from their lives. What does it do to the parental authority? Mother's parental authority also, by the way, which some short-sighted mothers don't see. For many kids, it's a revelation. Oh, there's somebody who actually cares more about me than my dad, and this person expects me to tell things that I will keep secret from my dad or mom. This is how blind trust in government is instilled from childhood. It is another time bomb deposited into children's lives, and this is how the government grooms obedient slaves. But, in a typical plausible deniability fashion, it is sold to the population as benevolent. The government is here to help, and the children need a voice. The facts of my case clearly prove a pattern of alienation. The move across the continent, ostensibly to find professional work as a registered nurse, which never materialized, the perjury in trying to register in an active agreement, the flip-flopping on the declaration to return to the previous schedule once I moved to New York as well. Rita Kaufman said in court at the beginning of this torture that she doesn't understand what I'm talking about. Why parental alienation? The children want to see me. This is the level of understanding of an attorney for the children. Recently, when I said the children have diminished capacity, they are hostages, they are afraid, they see that they almost lost the father, they don't understand why, they are afraid to lose the mother as well, they are little, they cannot get food or clothes on their own, they are physically little, even by size. So what the hostage suffering from Stockholm Syndrome is expected to say? Rita Kaufman said that she doesn't understand what I mean by diminished capacity, or pretended not to understand. Well, it's a term from the relevant literature. When I asked the head of the AFC panel, which is supposed to oversee and certify attorneys for children, whose name is Joanna Ender, what are the courses? What is the continuous education that the AFCs are getting as mandated by law? She refused to answer. So, how is Kaufman, a professional attorney, supposed to represent the children in high conflict cases if she doesn't understand or pretends not to understand the most prevalent dynamic in these cases, parental alienation? Is this the level of people that New Yorkers are supposed to pay for? And now, by the way, these state-assigned attorneys, 18B and AFCs, have the audacity to ask for more money. There's a pending case, and I encourage all victims of these state attorneys to submit their testimonies into that case. Now, look at the one common tactic, showing you how these people operate. They don't need facts, they only need a pretense. Kaufman accused me of violating the law regarding child safety seat during the January 21st, 2021 conference. I'm reading from the transcript. Ms. Kaufman, the second issue that I had was brought to my attention that the children were traveling in father's car unsecured, meaning they don't have booster seats or age-appropriate, I think they're called booster seats. Look at the broad smear. Please also notice soon to be even more evident, typically manipulative and obfuscating language, carefully created as a retreat line of plausible deniability if caught lying to the court. I think they're called booster seats. Who in this day and age doesn't know what is a booster seat? Are we supposed to believe that the family law attorney hired by the government to represent children, making a false accusation based on alleged lack of a booster seat, doesn't know if a booster seat is called a booster seat? 10 days prior to that, Ms. Kaufman made identical, deliberately false accusations via email. I do understand that the children do not have booster seats in the father's car. Based on their age and weight, they should be in those safety seats. That's what she wrote. Please note that, unlike when making the same false allegations in front of a judicial officer, Rita Kaufman is much more forceful when lying to a third party. No hesitation at all about calling a booster seat, and also an outright, clear-cut false statement. Based on their age and weight, they should be in those safety seats. 2 days later, on January 12th, Rita Kaufman kept pounding on this golden nugget that she thought that she found. She doubled down on her assertion that the children have to be driven in a booster seat, even after receiving a clear response. Does that mean that they have booster seats? She was elated that she found something to nail me on. The bad father, the irresponsible father. responsible enough to pay hundreds of thousands of dollars in support. But no, now the claim is that I turned absolutely reckless. Now to the crux of the falsehood and the manipulation. The age of Rita Kaufman's clients at the time Rita Kaufman made her knowingly false statement was 7 for my son and almost 10 for my daughter. My daughter didn't have to have any booster seat. And if Ms. Kaufman really represented the interests of the children, she should have paid attention to the fact that it was the mother who physically and symbolically, unnecessarily, has been restraining our daughter, further promoting the indoctrination and brainwashing. This is exactly how alienation works, by creating a constant, manipulative, psychologically suffocating reminders that the mother is caring for the children's safety more than the father. Any honest attorney could have easily determined that according to New York Vehicle and Traffic Law, Section 1229-C, subsection 2C, I'll talk in a minute about how the government writes and publishes these laws, only children that are age 4 or older, but under age 8, have to be restrained in an appropriate child restraint system. These provisions are also published on multiple government websites. Anyone could Google it, but Kaufman was happy to pounce on mother's complaint to promote the same manufactured fatherlessness agenda. This fact further shows Ms. Kaufman's astonishing audacity and clearly entrenched belief that she herself is above the law, that nobody would ever dare to double-check her, and that she is free to make deceitful, frivolous accusations, tarnishing the father in front of the court, in life-altering proceedings, shaping the future of his small children, with impunity. According to Section 3.3 and 4.1 of New York Rules of Professional Conduct, published in 22 NYCRR Part 1200, a lawyer is prohibited from knowingly making a false statement of law or fact. Rita Kaufman knowingly made a false statement of law or fact. When I worked as an attorney, I would double and triple check every statement, not to lose my license. But Rita Kaufman is not afraid of that, knowing that she is protected, which she was. At the same time, she sided with the mother on the smear campaign. Kaufman ignored health and safety risks of the children while in mother's care, as has been abundantly documented in my pleadings. For example, the mother was involved in at least one serious car accident with the children. On my calls with them, I heard strange beeps when they were driving with her. But the mother coached the children to stay quiet about it, and it seems continued to drive the children in an unsafe vehicle. I only learned about that because our daughter was so scared that she wrote about it in her school notebook. No reaction from Kaufman. The children told me that the mother left them alone in their small home to drive to do laundry outside. No reaction from Kaufman. Another example. During the May 25, 2021 court conference, I was blindsided and shocked to learn that Ms. Kaufman's colleague, another state-paid appointed public attorney representing the mother, Mr. Ian Berliner, sent an email to the judge behind my back. This ethical violation was so egregious that even the judge took special notice and formally admonished Mr. Berliner in no equivocal terms. Mr. Berliner will get a separate video. I'm reading from the transcript. The court. Well, Mr. Berliner, was Mr. Brick on the email? Mr. Berliner, Mr. Brick sent the email. By the way, look at the deception. This is not what he was asked. The court. No. When you forwarded it to the court. Mr. Berliner, I don't believe so. Look again at the deception. I don't believe so. The court. Okay. I'm going to admonish you. You can't do that since he is a self-represented litigant and this part, and I can't speak how other colleagues or other judges wish to run their part, but I will not have any communication with my chambers, whether in writing or any electronic communication, with respect to a self-represented litigant, because obviously he would be out of the loop. Rita Kaufman was copied on and received the behind-the-back email by Ian Berliner, but she did not bother to copy me on it, or indeed mention the communication to the judge, until the judge himself uncovered it. This is another blatant ethical violation by Kaufman. Lawyers like to mention that theirs is a self-regulating profession, so they have very nice-looking rules according to which they are supposed to monitor and report each other. According to Rule 8.3a, titled Reporting Professional Misconduct, a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer shall report such knowledge to a tribunal or other authority empowered to investigate or act upon such violation. Kaufman stayed comfortably silent about Berliner, and they don't like when I say that the mother got not one but two state-appointed attorneys. In Kaufman's November 2020 email discussing the Thanksgiving break that the mother refused to let me spend with the children, in contempt of the government parenting plan, Ms. Kaufman wrote the following: I do not know what the judge intended by the term school breaks, But normally they are Christmas week, President's week, and Easter spring break. I don't know if this holiday falls into this category. If the mother agrees, then I have no objection. How is it plausible that Ms. Kaufman, an attorney in New York, who ostensibly specializes in family law, doesn't know what a school break means? Moreover, how plausible is this that she doesn't know whether Thanksgiving falls into that category of a school break? One Google search and one mouse click would bring up the NYC Department of Education website and the school calendar, which lists the school breaks. And it doesn't differentiate, unlike Ms. Kaufman's misleading representation, between Thanksgiving recess, winter recess, or midwinter recess. All of them are recesses or breaks. Her attempt to present Thanksgiving as somehow different was clearly fraudulent and misleading. According to Rule 4.1, titled Truthfulness in Statement to Others, in the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law to a third person. Moreover, according to Rule of Professional Conduct 8.4, a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, and separately engage in any other conduct that adversely reflects on the lawyer's fitness as a lawyer. A family law attorney representing school-age children for a living who claims not to know what a judge meant by the term school break is either lying or incompetent, and either way should not be allowed to practice law, not to mention be paid by the people of the state of New York. If all this wasn't enough, and these are just several samples, Kaufman was formally admonished by another judge for a separate communication behind my back. The cavalier fashion in which she does that indicates that that's not the first time. When Judge McFarland is routinely late to the court, Kaufman has no comments. When I was late to CFS jail-like visit because of unclear communication, she immediately jumped on me, claiming that I'm not diligent enough to exercise my quality time, the morsels that the state graciously sells me back to be with my children. Look how clearly manipulative, twisting this lawyering is. This is the best interest of the children? To latch onto anything, to lie if there's nothing, take it out of context only to create pretense to prolong the separation, to ignore all the signs of alienation by the opposing party? This is how Kaufman represents the children's best interest? The examples above show you how Kaufman and other attorneys for the children operate. This is the typical method, twisting the narrative in every possible way to benefit the mother. How is this representing the true interest of the children, to have a normal relationship with both parents? But this is not the real interest, and this is not the agenda that Kaufman serves. She serves the agenda of her real client, the actual client who actually pays her, the government. This client doesn't want fathers in the kids' lives, and Kaufman will twist and obfuscate and outright lie about the governing law to serve the real client. This is the most egregious, overarching violation. Rule 1.1, incompetent representation of alienated children. The caseworker investigating the most recent false allegations did not recommend any separation. She conveyed that both kids report that they are missing their father, Roman Brick, and would like to see him more, with my son bravely asking for protection from constant verbal abuse. He would like to live with Roman Brick and only speak with the mother on the phone because she yells a lot. Yet, Rita Kaufman denied in a court hearing that our son said that. What a blatant lie. And the judges keep playing the same game. Oh, the attorney for the child. She is neutral. She is objective. Just to tell you what I did. I have submitted the complaint to the Attorney Disciplinary Committee, and it was routed to the same AFC panel. Why? It was supposed to be an independent institution. Well, I submitted the complaint to the panel, and it got brushed off as well. Now, the problem is not Kaufman. She needs to be disbarred and disqualified immediately. The problem again is the government hiding behind her. This is not a typical subversion layer out of countless layers. In truth, AFCs were created to bypass all time-tested protections against government oppression via courts. AFCs are a cover to introduce inadmissible evidence. They are also protected from cross-examination or any discovery to try and uncover the truth. I'll show you an example. When I asked Kaufman to know when she met with my children, not even the content of the meeting, Kaufman immediately claimed, as expected, attorney-client privilege. But at the same time, she has no problem to testify that my son never said to her that he wants to live with me, or that the children were distressed by this or concerned by that. You see, sometimes Kaufman is an attorney, and sometimes she's a witness, exactly as the government wants it. Now let me ask, why children need an attorney? Why they need an attorney-client privilege? Are they planning elaborate tax evasion schemes? Or Kaufman needs to plan intricate defense of a child who committed a horrible crime to which he confessed in front of her? And even let's entertain this thought for a moment. Let's suppose that was the case. Why not to record the meetings between the children and Kaufman and let us review them separately? Policemen Police officers wear cameras because the public learned that they can lie. Why another type of state-paid agent, AFCs, wouldn't record the meetings? What are they afraid of? What are they trying to hide? It is clear as day that this is precisely why this whole institution was created, once again for plausible deniability. My kids can beg and cry in every single meeting that they want to be with the daddy, they want to see me more. Mother yells a lot, but an ideological player like Rita Kaufman, who knows what her real client wants and who wants to keep getting cases referred by the same client, can and will lie, and the same client structured the laws precisely so we will not be able to prove her lying. And any indirect indications of her dishonesty and ethical crimes are, of course, ignored. Plausible deniability. The fatherlessness manufactured Moloch continues to eat children. Kaufman can say whatever she wants. She muffles and silences the children, frustrates them, and coaches them. My daughter mentioned during one of the supervised visits that it was Kaufman who keeps pushing her to interrogate the father, turning them into prosecutors. Look at the hypocrisy. The parents are not allowed to talk about the court with the children. But this is all what Kaufman is doing. She personifies the court. Bottom line, the whole institution of AFCs, working hand in hand with judges like McFarland, was created precisely in order to allow state agents like Kaufman to push the state agenda as if it was the children's interest. Maybe when the kids are 18, if they know where to find the father, will say, "We actually told Kaufman that we want to live with you, Daddy, but until then, Kaufman will be long gone and the irreparable damage will be long done." Despicable. A bit of legal analysis, how exactly it all happens. The courts in New York are given the power to appoint an attorney to the children, according to Section 249 of the Family Court Act. Now, the section lists a number of topics, articles, in which such appointment is mandatory. These are serious matters, such as adoption, termination of parental rights, and so forth. My case was simple. I only asked the court to revert to the previous plan from Seattle, as my ex-spouse solemnly promised to the court in Seattle in order to allow her to move, before she moved. And then she refused to let me see the children more than once a month. The court was not mandated to appoint an attorney for the children. This is what the law says in subsection A. In any other proceedings in which the court has jurisdiction, the court may appoint an attorney to represent the child when, in the opinion of the family court judge, such representation will serve the purposes of this act, if independent legal counsel is not available to the child. The family court, on its own motion, may make such appointment. Pay attention. May, not shall. It is discretionary. See how vague it is? Basically, the law itself preserves the judge's ability to do whatever they want. For us, the plebs, there is a law. Everything looks legit and serious. But de facto, it's complete tyranny. There are no standards. These attorneys are appointed left and right, and we, the public, cannot get any clear information how many are appointed, who are appointed, in what percentage of cases, how much they are paid. It's all deliberately obfuscated, as I will show immediately.